are now moving on to what would have been the 3 p.m. talk, which is Nick Stallworthy and Victoria Brown. If Nick is going to make a glorious process up the middle.
Are you going to give me away?
I tried that a long time ago. On section 57.
Are you going to sit? I'm going to sit. You're going to sit.
Yeah. So Nick and I are going to sit, you might have just heard. We are going to get up in each of the slides, so it won't really work for one of us to be standing at any given time. This is a talk inspired by a case in which we both acted recently, or less charitably, inspired by an opportunity to talk about ourselves for half an hour. It is familiar to some of you in the room, so heckles welcome from the back left maybe, but not from Nick Hill. Nick Hill acted for the Rep Ben, instructed by Gowling. Nick Stallworthy for the trustee, instructed by Osborne Clark, and I was for the company, instructed by Alan and Overy. Roughly speaking, Nick's going to take you through the law. I'm going to talk a bit about the case itself, and then if anyone's still awake, we're going to hopefully have a bit of a discussion about possible future uses of this jurisdiction.
Okay, section 57 of the Trustee Act is not something that they teach you on most trust courses at university. And for most pension practitioners, it's not a routine part of our day-to-day practice. But it's nonetheless quite useful for us to bear in mind as a tool when we encounter situations for which there is no power, and perhaps you can't use the amendment power to put one in. Section 57 of the Trustee Act 1925 provides where management or administration of any property vested in trustees, any sale, lease, mortgage, surrender, release, or other disposition, or any purchase, investment, acquisition, expenditure, or other transaction is, in the opinion of the court, expedient, but the same cannot be effected by reason of the absence of any power for that purpose vested in the trustees by the trust instrument, if any, or by law, the court may, by order, confer upon the trustees, either generally or in any particular instance, the necessary power for the purpose, on such terms and subject to such provisions and conditions, if any, as the court may think fit, and may direct in what manner any money authorised to be expended and the costs of any transaction are to be paid or borne as between capital and income. So there are the three key elements are that it has to be to do with the management or administration of the trust. Although there is reference to particular dispositions or other transactions, it's extremely broad because of the words at the end, or other transaction. And the overarching requirement is that the court has to be satisfied that it is expedient to confer that power. The key distinction to bear in mind is between the management or administration of the assets of the trust and actually rewriting beneficial interests. And the old cases like Danger Settled Trusts say that it's clear that the subject matter both of management and administration is trust property, which is vested in the trustees. And in our opinion, trust property cannot, by any legitimate stretch of the language, include the equitable interests which the settlor has created in that property. There are limits to that, as explained in Sutton and England and other cases about partitioning of trusts. While there's no jurisdiction under section 57 to confer a power to depart from the beneficial interests under the trusts, by rewriting, remoulding, or rearranging, that doesn't prevent granting powers which may affect the beneficial interests incidentally. For example, by partitioning the fund, you may find that assets that would before all have been blended and give all beneficiaries an equal increase in their entitlements. If you separate them, you may find that one bunch of assets performs better than the other. And you may incidentally find that one cohort ends up getting more money than the other, but that's not a problem. Next. The breadth of what you can do in terms of what powers you can introduce is extremely wide. It's important to note, as we were told in Cotterell and Allendale, that it's not limited to conferring a power for a specific transaction. It includes enlargement or variation of powers of management or administration generally. So it can be powers that you can use indefinitely into the future at such times as they're convenient. Although it's fair to say the court's pretty reluctant to give you powers that obviate you ever needing to come back for something new. You can't, in effect, give yourself an unrestricted amendment power to do whatever you like forever. It's not limited just to a power to affect the particular transaction that you had in mind, or just the general power itself. It includes ancillary powers to facilitate the operation of the new power. But it is, of course, limited by the overriding restriction that it's to enable the trustees to implement or undertake the transactions, or be a necessary ancillary provision relating to that additional power. And the sheer breadth of what you can do with Section 57 is shown by many of the cases, both in the private trust space, but also in the context of commercial trusts like bonds or other security or restructuring trusts. You can modify prescribed quorum requirements. You can substitute wider investment clauses. You can confer powers to adopt a completely new governing instrument where you don't have sufficient amendment powers. You can confer powers to appoint a sole corporate trustee when you otherwise couldn't. You can modernize the administrative provisions generally. You can even disapply a rule of law like the rule against self-dealing. And the overarching requirement of expediency has been variously described as if it is thought by the court to be in the interests of the trust as a whole, and in other cases suggesting that even if it's disadvantageous for some beneficiaries, it's sufficient if it's for the overall benefit of beneficiaries under the trust generally. And I just pause to wonder whether some of those old cases, talking about whether it's in the interests of the beneficiaries, might need to be slightly revisited in the light of what we're told by cases like the recent British Airways case, or cases like Grandview and One. Because, of course, in the recent British Airways litigation, we've been told that, and cases like MNRPF and Stena, it's not just a decision that, for example, you might use amendment power to increase benefits up to inland revenue maxima because it would always be in the interests of members to give them the highest possible benefits. You are constrained by actually what is the purpose of the trust. And there might be circumstances, which we'll come on to at the end, in which something might be properly within the purposes of the trust, but not in the interests of its beneficiaries. And there could be all sorts of interesting uses of Section 57 in the context of, for example, trapped surpluses.
So that takes us to me for now, and we start back in 1989. So whilst those either side of me were living their best lives, the water industry was being privatised, and a scheme was being created to mirror the benefits that had previously existed for those in the Water Authority's scheme. In doing so, various protections were baked into the rules of that new mirror image scheme, including a minimum of 2 member-nominated trustees, some restrictions to the amendment power, and whilst beneficiaries remained, vetoes to various provisions, so things like winding up employer contributions, etc. Those protections were all retained following a merger into that we came to be dealing with, the Penny Group pension scheme. I should pause there to say that at that point, the 2 member nominated trustees was increased to 3 formally, although that had been the case in practice for some time. We then get to 2021 and the mirror image section and various other defined benefit sections were all closed to future accrual. But one of the vetoes was exercised by the member nominated trustees, although by then member nominated directors of a sole corporate trustee. It all came out in the wash because individual agreements were reached with all of the active members in that section. But important for our purposes, and we'll come back to it in a moment, that veto was a real thing right up until 2021. By 2022, I think it's up there, members of the mirror image section were 8.9% of the overall membership, but represented by 50% of the member nominated directors. Some of us thought that was disproportionate. The trustee was reducing the size of its board overall, and as part of that, sought to reduce the number of Ms., as we called it, member nominated directors. They couldn't remove the pressure on the amendment power, not least because it had been part of the bargain struck at the point of that merger. And so all of that took us to section 57. Yes, please. Oh, not quite at section 57, actually. We are looking at here some of the restrictions that I've mentioned. So at the top, we've got the necessary to have 3 mirror image transferred beneficiary representatives. That's what I've been calling the Ms. member nominated directors. And then the restriction on the amendment power itself, we've taken out the long list of vetoes that they had, but that's what that refers to at the bottom there. So that takes us to our decision. And by way of spoiler, the master did grant the application. He was satisfied that he had jurisdiction and exercised his discretion. But I think the real interest is in the detail of the approach that he took to the key elements that Nick took you to earlier of section 57. And I'm going to take the easier ones first to warm us up to the deeply academic exercise that I'm going to ask you to engage in a moment. So starting with expediency. My own view, and I think it's shared, but I won't speak for the others, is that that was pretty straightforward. It's clearly right that efficacy of decision making, proportionality, etc., required, or at least was benefited by, a reduction in the number of Ms. member nominated directors. Although, as I say, it's worth pausing to think that the protections did have some real value in very recent times. So they weren't hollow relics of the past entirely. But the reality, I think, by this year when we were making this application, is that it was hard to see how the protections might actually bite again in the future. Accrual had ceased, so section 67 protected modification of past service benefits. The legislative landscape had changed, so employer contributions were ensured or mandated by the Pensions Act 2004. Was really only something like a bulk transfer out or triggering of winding up maybe, where the vetoes that did exist could bite. And in any event, of course, those protections were staying completely in place. It was just that there'd be fewer people directly tasked with upholding them. But all the trustees, of course, would have to comply with them in any event. The judge agreed that that bit was easy. The master said it's absolutely clear that it is expedient to make the change. Another straightforward bit was discretion. Case law says if the other elements are satisfied, then you should probably do it unless there's a good reason. And the judge said, yeah, that sounds good. But the real interesting bit, I think, is that portion of section 57, the real chunk of it, that deals with transactions. I don't know, Amber, if you could be persuaded to go all the way back to the slide of section 57 on it, but if not, no worries. There's a long list of the types of transactions that might exist, but nonetheless, I confess that at first blush, I didn't immediately see that what was sought, thank you very much, would fall within that list. The trustee put their case in two ways. One, it could be done by way of amendment to the trustee rules. Or two, you could just straightforwardly reduce the number of directors. The trustee and the company favoured the amendment option, but Nick Hill, I think it's fair to say you weren't so with us on that.
Yeah, I think that's fair. I think you get to the same place either way you do it. I think the reason I slightly favour the reduction on the mismember trustees is Victoria mentioned discretion just then. The discretion is still an element of what to consider. When exercising discretion in this case, it had to identify the interest of the settler, which were that there should always be a certain number of mismember trustees. And it seemed to me that in considering the exercise of that discretion of reaching the settler's interests, it was cleaner there to be a straightforward direction as opposed to a textual variation. With Master Pester, and he had almost no interest in the argument, it's fair to say, because he was utterly persuaded it's the right thing to do. But that was why I favoured slightly the other option.
Nick's done a bit of a spoiler of what's coming there, but you'll hear it in a little more detail. The first way that I think it could have been considered, and I was initially attracted to this because it's straightforward and easy and I like that, is whether or not it could just be a disposition. And I think in another very similar life that could have worked. So if there wasn't a sole corporate trustee and the trust property was moving from, say, 10 trustees to 7, then I think that may well have worked as a disposition. But here, I don't think it could because of the sole corporate trustee. So I don't think there really was any actual movement, at least not to a different legal entity. So that takes us away from the nice straightforward route and back to finding a way for that to be a transaction. We did all agree, although with varying enthusiasm, that amending the text of the deed and rules could be a transaction. And I think the clearest way to do that on the authorities is to say, because powers include the power to do anything necessarily ancillary to the objective, we saw that a moment ago in the Cottrell, that includes a power to amend the scheme documents to give effect to the new way of management and administration. But the alternative route, as Nick says, was simply reducing the number of directors and then allowing them to continue to manage the scheme. There are arguments on both sides, I think. For myself, the transparency of an amendment to the scheme documentation had a benefit, and that couldn't be done without it being an amendment because the court, because of the restriction on the power. So what did the master make of all of that? Well, as Nick indicated, he said, you know, that's all of it, not his words, that's all a very nice legal debate you've all had there, but I don't have to decide that, do I? Please say I don't have to decide that. I'm definitely not going to if I can get away with it. And we all said you can definitely get away with that. He did then say in his decision, if I'm absolutely forced to choose, I'll go for the textual amendment. But again, really don't make me. And either way, I'm satisfied I've got jurisdiction. I'm going to be a pain now to say, can you go all the way back to where we were? Which ones? One back. Procedure, super straightforward, exactly like rectification. 1-page claim form, witness statement explaining things. You may want to serve a draft skeleton to convince your opponents. One thing probably worth mentioning is the master thought and commented on the need for all parties to be there, and in particular the importance of the role of the rep ben in a case like this. But I think one can foresee here, perhaps more so than rectification, where there's unlikely to be much choice, that clients may say the game's just not worth the candle. Yeah, it would be great to reduce, say, the number of trustees we've got, but it's going to cost me so much to do it. Never mind. But there will be times where we think they might be more enthusiastic. I think takes us back to Nick.
Yeah, shout out to Catherine King and Oswald Clark for saying, let's do this. So thank you for, I think, a very unusual use of section 57 in the pensions context. It's useful for us all to be reminded that it exists and that we can do things that we simply otherwise can't do using section 57. So let's just have a little think amongst ourselves as to what sort of things that might be in the modern era. Well, sometimes, for example, you have an insolvency that happens rather faster than everybody had seen coming, or the trustees aren't given perfect visibility that it's about to ensue. And you find that you've got an amendment pattern, or which does not have an express provision that it continues to be available during winding up. And you probably know that a handful of cases saying that, old cases, that unless you've got express indication that it continues, often the trusts determine you have to wind up and you've got no amendment power left. And you might have a situation where there's a long assessment period and then you emerge from the assessment period because you're just over PPF level. And you find out there are all sorts of things you'd like to do in the modern era that you just can't do because you've got no amendment power. Well, you can do it with section 57. And you might say to me, well, that's all very well, Nick, but you know, how often are we going to want to do that? Well, you might have things like reducing the number of trustees or removing other sort of privatization era restrictions or requirements, whether they relate to a trustee or other matters. Or they might, particularly in the modern era, and I think this may be an area of interest for people, is dealing with surpluses. Sometimes you've got very restrictive provisions as to whether or not you can return money to an employer. You might have provisions that, on the face of it, seem to require you to increase members' benefits up through the roof. You might have situations where actually you can't increase members' benefits any further because they're at prescribed max around. The employer doesn't want to increase their benefits anymore, thanks. But you then can't get the money out. Well, you could use Section 57 to do something novel like merging another scheme in, or conceivably moving money out into another occupational pension scheme. The boundaries for what you can do are still relatively untested. And I saw recently a situation which seemed a possible use of Section 57, two sister schemes, which had always been run very, very much together. At the beginning of a very lengthy assessment period, one seemed underfunded and the other seemed overfunded. As it happened, their investments behaved in entirely unpredictable ways. So the fact that all of the recoveries went into one rather than the other meant that their funding reversed. And the obvious thing to do is to merge the schemes. But you might say, well, can you really do that? Because even if there's funding for everybody to have all of their benefits covered, you might be denying the members of one scheme augmentations that they might otherwise get. And all sorts of questions about whether you can do that. But you can see that using Section 57, the court might be prepared to do so. But if anybody else in the audience has got questions as to, or ideas as to how it could be used, it'd be very interesting to see whether people start coming up with imaginative ways of using Section 57.
You think of something the BBC?
Well, it would be flagrantly affecting the beneficial interests. So it would be out with the scope of Section 57, I suspect. If your use of Section 57 may affect benefits, but only incidentally, that may be permitted. So the example I was giving of a merger, oh, well, it's an administration and management issue because we're just trying to merge some schemes and would like to effectively use an amendment power to do so. As it happens, it might mean that we might not be giving people huge additional surpluses which were no part of what they were promised. But that's ancillary to the ultimate objective of mergers.
Is it ancillary or is it a transparent?
Well, I think that would be the debate in front of the court. And I can imagine the court being pretty sympathetic to whether or not the background facts made it expedient in the sense of fair and consistent with the purposes of the trust.
I was going to ask you to clarify it because of the reference in Section 57 to the absence of any power.
Yeah.
We're talking about your rules that don't give you an express ability to do something, not where there is an express prohibition.
No, but yeah, very good question. And there are cases about that, in particular in the context of things like employee benefit trusts and other matters. And the case law is now clear that, as in this Pennon case itself, Section 57 is available to override an express restriction. Something that has been deliberately put in as a prohibition can still be overridden if it is in the interests of the trust as a whole. Perhaps unsurprisingly, if it's a long historic fetter, which you wouldn't have in the modern era and was put in for now defunct legacy reasons.
If you take the case of the surplus on an ongoing basis, different obviously to traffic on a winding up basis, you might well run lots of schemes do have the prohibition on returning payments to the employer during the life of the scheme. Two things happen unless you passed a resolution anyway to preserve a power that you might have had. You can't. I don't think you can resurrect that now. And so, can you override the legislation as well as your rules and giving yourselves a new power to return surplus on an ongoing basis where there was restriction in your rules in doing so?
When you say override the legislation, which
has plus 251 resolutions.
Oh yes, yeah. Well, of course, Section 57 says not only in absence of a power under your instrument, if any, or any other law. So
well, I was going to say they did it with self-dealing.
Yeah.
And they did it with context of one of the other.
Of course, that wasn't statutory, it's a trust law.
fixed.
Yeah.
That's a statutory, like maybe out of Jersey though.
Yeah.
But
But
it has been done, so.
it has been done. And I'm sure you're right that in deciding what is expedient, and even if it might otherwise be expedient, the court has a discretion as a sort of a last stage of the inquiry. The court might well simply say, it's not expedient for me to go around flagrantly breaching a deliberate legislative intent to prohibit something.
But it could be to break a deadlock between the company and trustee and trying to do evaluation.
Yes.
Because that's often the answer.
Conceive- I mean-
Surplus, it's when I can't get my hands on until I wind up the scheme, which might be years off.
Yes, I suppose there might be certain circumstances in which they said, well, you've got Part 3 of the Pension Schemes Act, which has a whole regime intended to deal with that, including the regulator intervening and imposing answers. But I can see circumstances in which, in the context of things like mergers, you might. The other area where people might start being really inventive with it is retrospective changes, because you'd say, well, if there's no restriction on your amendment power under the governing documentation, you can make a retrospective amendment. It might be voidable by the regulator, but whether the regulator will engage, the regulator might say it's not going to. If you do have a restriction on your amendment power, so you can't do it, might there ever be circumstances with, for example, botched closure to accrual, where you turn around and you say, look, the suggestion that we've got an extra 10 years of accrual because of a failure of a documentary formality is ridiculous. Can you give us the power to make this change retrospectively? I mean, that would be a pretty heroic application, but you can imagine people reminded of Section 57 and the flexibilities that it gives, coming up with all sorts of circumstances where it would be useful. But you can override. Sorry? Well, the three of us were involved, so all three are available. But you can override express restrictions. What the court would probably be reluctant to do is fly in the face of a deliberate legislative intent.
Can the employer use the power as well then? So
No.
exposure to accrual power, then
It's
can't
only for trustees.
Yeah, trustees would really are that's you have exposed to. But an employer might, but they can't.
Yeah, I mean, I think trustees are in a pretty embarrassing situation, and I've got quite a few of these cases where they're the ones who got it wrong,
Yeah.
and all of a sudden people are saying, what do you mean you've racked up another 50 million over the last decade? I mean, that's pretty awkward in terms of your funding discussions.
And it's taking a long time to work out that there was an error made
Yeah.
when administering the scheme.
Quite what the limits are of Section 57 are quite well established in the private trust context. There are Section 57 cases in the commercial context, EBTs, restructuring and security structures. I'm not aware of any other case in the pensions context. That's right. Yeah, Mason and Farbrother in the 80s, where they didn't have an amendment power and they were allowed to do. Yeah, that's so. There's definitely.
That's 1983 though, so time for.
You've already said. On that note, although that's produced some fantastic questions, thank you. We will start for a moment.